Hello friends, my name is MK Reddy and in this video we will be discussing about evaluation of Collegium system. We will try to understand in this video how this Collegium system emerged and what are the constitutional provisions with respect to the appointment of judges of High Court and Supreme Court, and what does various Supreme Court judgments and cases say about Collegium system, and we'll be discussing about judges case 1, judges case 2 and 3 and 4, and also we'll discuss National Judicial Appointments Commission and why it is called illegal, why it is scrapped by the Supreme Court. So we'll be discussing in this video the various aspects that are attached with the Collegium system in India. Ever since 1970s, it is so much in news. So we'll try to understand why it is in news, and we'll also try to understand the constitutional provisions with respect to the appointments of Supreme Court and High Court judges. As you could see on the screen, my dear friends, Article 124 of the Indian Constitution say about appointments that President of India will appoint the judges of Supreme Court and High Court by consulting the Supreme Court judges and High Court judges. So the Constitution says it is the President who appoints the judges. We all know that over the years there are some conventions, especially which are not mentioned exclusively in the Constitution, and one of the convention is appointing the CJI of India, Chief Justice of India, and it is as per the convention which was initiated by the then Prime Minister Jawaharlal Nehru, appointing senior most judge of Supreme Court as the CGI. This trend was started by the very first Prime Minister of India, Jawaharlal Nehru, and it was continued for so many years. So this convention was broke on several occasions, like as you could see on the screen. It was not followed in 1964 and 1977. There are various reasons behind this, so we'll try to explore the reasons also. In 1973, we all know that there is a famous case. It is called as a Keshanand Bharati case. It was a 13 members judges case, and in this Keshanand Bharati case, we all know that it tried to bring out the power of parliament, and it tried to bring clarity about the clashes between judiciary with respect to the powers of parliament to amend the constitution. So this 13 member judgment, it was split with 7 and 6. So it was narrowly passed or marginally passed, and the four senior most judges, the very first the first three senior most judges supported this Keshanandi Bharati case. They are in the seven. The top three senior most judges were top three senior most judges are in the favor of this case. So these three judges who supported this case, who were in favor of this case, were not appointed as the CGI by the then government, Indira Gandhi government. And why? Because we all know that President of India appoints them. So this appointing CGI, the senior most one, is discarded and broken in 1973, most importantly. So before that also, in 1964 also, there was a violation of or coming out not following that convention, because in 1964 the reasons were so much justifiable, because in 1964 the senior most judge was so much not serious about his position. He was having some leaves. He came after so much of gap. There was no any controversy with respect to the breakdown of convention of appointing senior most judge as a CGA. However, as we saw already, 1973 case on the Bharati case, not appointing in 1973 senior most judge because of the verdict of the question on the Bharati case. So this says that there is intervention of politics or government in the appointment of the judges. Again, it was not followed in the 1977. As you could see on the screen, my dear friends, in 1977 there is a reason, valid reason. In 1975 and to 77, we all know that there was an emergency. in during this emergency to safeguard security, there are some cases, some acts and laws by the parliament, and in these cases there was like with respect to arrest of a person. So in this case, it was a 5 member. The bench strength was 5 judges. So it was those who are in favor of this verdict are at 4, and those who are not in favor of arresting a person immediately. So is one person who is against this verdict, who is against the government. So that very judge is in line to become the next CGI. However, since he is against the government, so he was not appointed as the Chief Justice of India, which makes us to believe that again political intervention could be seen in the 1977 also. This leads to the problem of what does it mean by consultation, whether it is binding on the President of India or not. What is the role of CHI and role of the judiciary, be it Supreme Court and High Courts. In order to address these problems, Supreme Court came up with some interpretations, and it came up with one of the most beautiful and one of the most sounding and most confusing and most importantly mostly discussed thing in the appointments, which is called as a collegium system. And most importantly, this collegium system, how it got evolved, and it didn't happen overnight. It happened through various cases. So we will see in this video all those cases. And in the very first case, which is called as a first judges case, which happened to be in 1982. In this case, Supreme Court said that it brought clarity with respect to the consultation of President of India. And it said that consultation does not mean concurrence. It just means what? Exchange of views, which means the advice rendered by the Supreme Court, rendered by the CHI, is not binding on the President of India with respect to the appointments and transfers. So, in the first judge case, the Supreme Court said that the advice rendered by the Supreme Court is not binding on the President of India. In the second judge's case, Supreme Court clearly said that the consultation now, which is not binding in earlier case in 1982, is reversed, and this time Supreme Court said that consultation would be binding on the President, which means consultation means concurrence, which means it is binding on the President of India, advice rendered by the judiciary, the judges of Supreme Court and High Court. And not just that, Supreme Court came up with some beautiful concept, which is called as a when CGI gives his advice during the process of consultation. So he will consult with what? Two senior most judges. So CGI will consult with what? Two senior most judges and will send that in the written form to the President. So this is the process which was clarified by the Supreme Court in the second judge's case, that the advice tendered by the Supreme Court would be binding on the President. However, in the third judge's case, which happened to be in 1998, Supreme Court said that not the consultation of not just two judges, 4 judges will be taken into consideration. So there will be a CGI and there will be a 4 senior most judges. Since it is the opinion of the 4 senior most judges and CGI, the advice provided by this collegium would be binding on the President. However, President could send for reconsideration, send back. If the Collegium sends the same list, same recommendations, in this case, the President is bound to accept the recommendations. Pouring or inspiring from the various appointments commissions from the all over the world, particularly United Kingdom and USA. The Parliament came up with some beautiful idea, which is called as the NJAC, National Judicial Appointments Commission, National Judicial Appointments Commission, and this commission would regulate or would recommend or would look after the appointments, transfers of judges of Supreme Courts and High Courts, including appointment of CG and all these things. So this NJAC was brought into limelight through 99th Amendment Act of 2014, and this would be replacing what the existing Collegium system. And there are various provisions in this NJAC Act which are not complementary to the independence of judiciary. So the Supreme Court declared this NJAC as unconstitutional and void in the fourth judge's case. And Supreme Court said that the earlier method of collision system would be continued. And let us see the reasons why this NJAC was called as unconstitutional or declared as void by the Supreme Court of India. So as you could see on the screen, my dear students, my dear friends, that this commission would be consisting of these kind of persons, and the chairperson would be the Chief Justice of India, and it will consist of two senior most judges of Supreme Court, or two senior most judges, which means who are next to the Chief Justice of India, and they are also ex officio, and CGI is also ex officio. So, and there are other category or kind of people in the commission. One is Union Law Minister, Law and Justice Minister, is also ex officio, and there will be two eminent persons to be nominated by a committee. Again, see, this is where the problem arises here. Two eminent persons to be nominated by a committee. So there will be another committee within this commission, and this committee would be consisting of these persons. One is CGI, the Prime Minister of India, the leader of opposition, and in case if there is no single party which does not get 10% of seats, if your party gets 10% of seats, it will be declared as a leader of opposition. Or in case if there is no leader of opposition, there's a single largest party. What? Single largest party in the Lok Sabha will be declared what? Leader of opposition. So this committee to nominate these two persons, and there is one more among the two persons, there is one more condition, that among the two those two persons, one person would be belonging from SC or ST or OBC or minority or women. Minority communities are women. So one person, the one eminent person, should belong to these categories or these sections, and these two persons, two nominated persons, will be nominated for the period of how many years? 3 years. What? 3 years, and they are not what? Not eligible for renomination. So they would be discharging their duties for just once, and they are not eligible for reappointing as a part of this committee. Supreme Court said that the independence of judiciary is so much part of basic structure, independence of judiciary, and this prevalence of executive or political executive in the appointments of judges, like leader of opposition, like two eminent persons, and like prime minister and a law minister. So these are political persons, and these persons may lack the knowledge of legal knowledge. So, and the ambiguous of these two eminent persons also. And the foremost is the encroachment of union executive or government into the judiciary made the Supreme Court to discard or to declare NJAC as unconstitutional and void, and to uphold the existing or the previous system, which is called as a Collegium system. Thank you, and I will come up with a new topic in the next video.